Good afternoon, everyone. My name is Malia Schultzman. I'm an attorney with the National Housing Law Project in San Francisco. Welcome to VAWA's Housing Protections, and I'm joined by my colleague today, Navneet Graywal. The National Housing Law Project is a technical assistance provider for Office on Violence Against Women Legal Assistance for Victims grantees. What that means is that we're here to support all of you in the work that you do. And we're always available to answer questions, provide training and materials, and to support you the best way that we can as you have housing questions that affect survivors of domestic and sexual violence. On the last slide, you'll find our contact information where you can reach us if you ever have any questions on housing issues relating to the rights of domestic violence and sexual violence survivors. So before we begin, I wanted to go over the webinar interface. You should have on your screen a viewer on the left side where you're seeing the PowerPoint. You can make it bigger by grabbing the corner. You'll also have a control panel on the right. To make the control panel smaller, you can click the double arrows. And I'm a little bit frozen up here, so we'll see if that, there it goes. So you'll see that you have a control panel. You can join today's webinar either by the phone or by using your computer speakers. We recommend that if you're having trouble with the audio quality that you do call in using your telephone, and the dial-in number and access code will be on your control panel. It won't be the number so that you see here. Today you are all muted. Unfortunately, we've had some experiences in the past where we've had some unwanted background noise during webinars. We found the best solution is to mute everyone. But please do submit questions using the questions box on your control panel. We also encourage you that if you've had any great success stories in using VAWA's housing protections, that you share some of those success stories and tips that you've used and have found successful. We will be taking questions at the very end of this presentation. All right, so a couple of additional housekeeping items. Materials were emailed to all registrants this morning. Those materials included the PowerPoint that you're seeing right now. We'll re-email those materials again after the webinar along with evaluations. We do really value your feedback, and we make adjustments to our webinars based on those evaluations, so we really encourage you to complete those. We'll also post the materials and recording at our website, and the link is on this slide. And for those of you who are California attorneys seeking NCLE credits, we'll email out those certificates after the webinar. So at this point, I wanted to run a couple of polls just so we know who's in the audience. So first of all, we're going to ask which best describes you. We've got legal services advocate or attorney, domestic violence or sexual assault advocates, domestic violence or sexual assault coalition staff, state or local government employees, or other. So I'm going to leave the poll open for a couple more seconds so you can all respond and we can see who we've got on the line today. All right, so it looks like we've got about 73% of you who are legal services advocates or attorneys. 18% are domestic violence or sexual assault coalitions, domestic violence or sexual assault advocates. About 2% of you are coalition staff, and 7% of you are other. So let's run one more poll. The next thing we wanted to find out about is how familiar are you with VAWA's housing protections? Are you very familiar, somewhat familiar, or is the question, what are those housing protections? And of course, that's what we're covering today. And again, we held this webinar because we wanted to do a basics session for those of you who are beginners or those who just wanted a refresher course. So I'm going to share the results now, and it looks like 5% of you are very familiar. So you are the group that are going to share your tips and tricks for using VAWA in the questions box. 67% of you are somewhat familiar, and 28% of you are really seeking some additional knowledge today, so that's great. Okay, so let's talk about our goals for today's webinar. First of all, we want to give a quick overview of federally assisted housing programs. And I recognize that some of you are extremely familiar with these programs. You deal with them daily. But we wanted to make sure first that everyone is on the same page. And I promise the overview will be quick, but it's very important that we all have a basic understanding of those programs. We'll provide some examples of how the Violence Against Women Act, or VAWA, housing protections have arisen in practice. We'll then go into the basic black letter law, talk about some of the new regulations that HUD has published to implement VAWA's housing protections. And finally, we'll address some advocacy strategies. Today, we are solely going to focus on the Violence Against Women Act and how it affects survivors living in subsidized housing. However, we recognize that a lot of you are assisting survivors who live in private, unsubsidized housing and who therefore don't have the protections of VAWA. So we want to let you know that there are other protections for survivors regarding their housing rights. We won't be going into detail about those today, though, because we're offering a future webinar on that topic. So what I wanted to get across here is that in addition to VAWA, survivors have protections under state landlord-tenant laws, state fair housing laws, and the Federal Fair Housing Act. We're going to cover fair housing protections for survivors on March 23rd, 2011, and we'll send out a registration link for that next webinar for those of you who want to attend. Additionally, if you have questions about what protections your state offers to domestic violence survivors regarding their housing rights, we've created a 50-state compendium that sets forth all those protections, and the link is here on our website. And we'll show you the website again toward the end of the session. So with that, I'm now going to turn over the presentation to my colleague, Navneet Grewal, who is going to give a brief overview of the federally subsidized housing program.
Hi, everyone. So we're going to go over those federally assisted housing programs that are affected by the Violence Against Women Act. So these are the programs that are covered by VAWA. It is not every single subsidized housing program. So it's important to know which ones they are. The first is public housing, and we'll talk a little bit about what the characteristics of public housing are. Section 8 is the Section 8 Housing Choice Voucher Program. Both of these programs are ones that are administered by public housing agencies. The third is the project-based Section 8 program. And then finally, supportive housing for the elderly and supportive housing for the disabled. So you'll notice that there's a number of programs that are not covered here. For example, rural development programs, tax credits, a number of the other multifamily HUD subsidized housing. And as Malia already mentioned, private housing does not fall under VAWA's scope. So again, all of those may be covered by fair housing laws, so I really encourage you to join our webinar in March to go over those sorts of housing. And we're available at NHLP to help you figure out what kind of housing your clients are in. So the first kind of housing covered by VAWA is public housing. As I mentioned, it's owned and operated by a public housing agency. The PHA develops its own leases locally. They're the landlord in this situation. And those leases are in accordance with HUD rules. The tenant either pays 30% of their income towards rent or flat rent. So usually if you have a client with a very low rent and is living in hard units that's operated by the housing authority, then you know it's a public housing unit. And importantly, we'll discuss this a little later, but the public housing agency also develops a local plan for running their housing, which includes all of their discretionary policies. And later on, Malia will talk a little bit about why that's really important for protecting survivors of domestic violence and stalking. The next type of housing, well, this isn't quite housing, it's a subsidy, is Section 8 vouchers. And what a voucher is that a tenant receives a voucher to rent a unit in the private market, and the lease is entered into with a private landlord. It's the public housing agency that pays the subsidy to the landlord, though. So there are 3 parties involved in this kind of housing. The tenant pays the difference between what the housing agency is paying to the landlord and the actual rent for the unit. So usually that's going to be 30% of the tenant's income. And a really important feature for the voucher system is that they're portable. You can use them anywhere, and you can move with vouchers to another unit. And similar to public housing, the PHA will develop a local plan for running the voucher program that will also contain its discretionary policies. So we have project-based Section 8. So the owners of project-based Section 8 buildings are usually private owners, sometimes nonprofits, and they receive subsidies to provide the affordable housing. How can you tell that your client is living in project-based Section 8? Well, often the tenant will be paying 30% of their income towards rent. So again, that's a key factor. This one's a little bit difficult to figure out. So this is one where I would strongly urge you to contact us if you suspect that your tenant has some sort of subsidy but are not sure what kind it is. The subsidy here is attached to the unit, and you can't move with the subsidy. And finally, we have the Section 202 and Section 811 programs. These are supportive housing programs for the elderly and for the disabled. They're run by nonprofit organizations and are focused, again, on very low income. So like project-based Section 8, the residents are paying 30% of their income towards rent. And so again, those are the type of housing where it may be difficult to figure out if your client's in it. You can contact us. And with that, I am going to move into, I'm going to kick it back to Malia, who's going to give some examples of how VAWA's protection may come up.
Thanks, Navneet. So we wanted to give you some practical examples of how VAWA comes up in practice. And today we're focusing on some examples that illustrate some really developing areas under VAWA's housing protections and some areas where HUD has decided to issue some additional guidance recently. And so these are sort of the hot issue areas under VAWA right now. And I'm going to go over a couple of case studies, and we'll then go over the law. So don't worry, we'll come back to the case studies and tell you what eventually happened in the end. So actually, I need to skip past Navneet's presentation. Sorry about the delay here. Okay, here we go. So the first client we're going to talk about is Eva. And Eva was applying for public housing. She went to the Housing Authority because she wanted to qualify for a public housing unit. And she was asked when she went to the Housing Authority to complete an application. On the application, anyone who wanted to get into public housing was required to disclose arrests for violent criminal activity. Now, Eva was a limited English proficient individual. English was not her first language, and she had been arrested twice for assault, both times because police officers believed her abuser, whose English was superior to hers. And this is actually a trend that I know many of you are seeing in your communities, where many immigrant survivors are often arrested mistakenly because of their lack of English proficiency. Eva disclosed the arrest on her application. She didn't want to be accused of fraud for failing to disclose the arrest, but she did make a note that the charges had been dropped in both of the cases. And unfortunately, the Housing Authority denied Eva's application because of the arrest. And I just wanted to show you the application itself. You can see why she was sort of between a rock and a hard place. The application strictly said, have you ever been arrested for any of the following criminal activities? And one of them was violent criminal activity. And she really felt that she could not honestly skip over that question because she had, in fact, been arrested but never convicted of violent criminal activity. So as you can see, this is a common obstacle that survivors often face in applying for subsidized housing. And in the end, we'll come back to Eva and find out what could have been done in her case. I now want to talk about Sonya. Sonya had actually gotten into the Section 8 voucher program, and she was using a voucher to rent an apartment from a private landlord. And one night, unfortunately, her abuser forced his way into her apartment, and he cut himself on broken glass after he destroyed a cabinet in her apartment. Her abuser then went to a security guard and said, "She stabbed me, that's why I'm bleeding." And of course, this was not a true story, but he was doing it basically because he wanted to get her evicted. And in fact, Sonya's landlord filed an eviction action against her on grounds of nuisance because of the alleged stabbing. And so on this slide, we're going to show you the 10-day notice to terminate that she received based on this alleged stabbing. And you'll see that the notice states that the landlord has received information that there's been several other domestic disputes between you in and around the building, and upon information and belief, you had an order of protection against the perpetrator previously. Anytime you see this type of language in a 10-day notice to terminate, or any type of eviction notice, it should really raise red flags that VAWA might be involved. Anytime that a housing provider is seeking to terminate a tenancy based on the fact that there's been domestic disputes between your client and someone else, or based on the fact that you had an order of protection and you allowed someone into your unit, again, those sort of raise red flags and might be an indication that this is a case where VAWA applies and could protect your client. The next client I wanted to discuss, and we'll come back again to Sonya at the end, but the next client I'll be discussing is Maya, who lived in public housing, owned and operated by a housing authority. Maya missed 2 mandatory meetings with the housing authority to go over her income, and she missed those meetings because she was terrified to leave her home due to constant harassment and threats and surveillance by her stalker. And the housing authority sent her a notice saying that she could be evicted for missing the meetings, that if she missed future meetings with the housing authority, she would, in fact, receive a termination notice. And Maya decided that she wanted to go on the record and explain why she missed those meetings. So she filled out a HUD form that's available on HUD's website, and we'll show you that later today. She filled out a form documenting the stalking and explaining why she had not been able to attend those meetings. And the housing authority told Maya that she was actually required to provide documentation of the stalking from a third party. Housing authority did not think that the self-certification form she had submitted alone was enough. And they told Maya that unless she provided some sort of third-party evidence, that she could be evicted. The next client I'll talk about is Jen. Jen also was a Section 8 voucher holder. She and her husband, AJ, and their children lived together in a unit owned by a private landlord, and they received their Section 8 voucher from the local housing authority. AJ was listed as the head of household on the voucher and had always completed the voucher paperwork, been in charge of communicating with the housing authority, things of that nature. Jen obtained a restraining order against AJ due to incidents of domestic violence against her, and the restraining order excluded AJ from the family's unit. AJ then went to the housing authority and asked the housing authority to let him use the voucher to move into a unit by himself. And when Jen found out that this was going on, she also went to the housing authority and asked the housing authority to let her keep the voucher in the interest of her children. And unfortunately, since AJ was listed as the head of household, and the housing authority generally had a policy of assigning the voucher to a head of household if the family broke up, they let AJ move with the voucher and terminated Jen's assistance. So I'm going to get into our last client now, which is Isabel. And Isabel, again, is a Section 8 voucher tenant. She had gotten her voucher from the Housing Authority and used it to rent an apartment, and she signed a year-long lease. Unfortunately, about 2 months into that lease, her former partner found her at the unit and assaulted her. And for her safety, Isabel moved out of state, and she asked the Housing Authority if she could use her voucher at her new home. As Navneet explained, Section 8 vouchers are portable. In other words, you can use them in any jurisdiction that has a housing authority. And so that's what Isabel wanted to do. She wanted to take her voucher, use it someplace else for her safety. And unfortunately, the housing authority told Isabel that she had violated the rules, that she couldn't take her voucher someplace else because she had moved out of the units without notifying the housing authority. And she also could not exercise her right to move because she had moved before her one-year lease was up. This is a common policy that a lot of housing authorities have, is that you cannot move during the first year of your Section 8 lease. And so, as you can imagine, this creates a lot of problems for survivors who need to move for their safety and also need that continued Section 8 voucher assistance in order to make their housing affordable. So now we actually wanted to turn it over to all of you and give you a chance to tell us about the housing issues that you're seeing in subsidized housing that are affecting survivors of domestic violence. And so we just want to hear from you if your clients have been denied access to subsidized housing for reasons related to domestic violence. And if so, if you could just enter, examples into the question box and tell us, why have your clients been denied access to subsidized housing for reasons related to domestic violence? We also want to hear from you if any of your clients have been evicted from subsidized housing or had their rental assistance terminated for reasons related to domestic violence, or even if they have faced a threatened eviction or termination that related to domestic violence. Let us know, why were they threatened with eviction or termination, and why was their subsidy terminated if it was. So if you could go ahead and enter any responses in the chat box, and then we'll share. Again, the whole point of this is just so that we can talk about common issues why your clients might face denials of subsidized housing or might face eviction or termination for reasons related to domestic violence. And I think our audience might be a little shy because we're not seeing, at least I'm not seeing a lot of responses in the chat box. So I'll just wait a couple more minutes to see if anyone's willing to share reasons why, again, you have clients who are victims of domestic violence who are unable to get into subsidized housing or stay in their subsidized housing. Okay, so we've gotten a couple of responses now. One person is telling us they had a client who was evicted for excessive police responses, and some of the responses to the unit were domestic violence calls. Somebody else has said that they are seeing issues where they have clients who need to move during the first year of the Section 8 lease, and they're not being allowed to move. And they've also had issues with the head of household topic that we discussed earlier, where they're seeing that the housing authority is just automatically assigning the voucher to the head of household in cases where the family has broken up due to domestic violence. We have another respondent who's saying that they have clients facing lease termination and voucher loss due to damages caused by the batterer. Someone else is saying they're seeing issues where a couple of parties are on the lease, there's incidents of domestic violence, and they're having trouble getting the housing authority to agree to remove the perpetrator of violence from the lease. We have someone else saying that they have clients who are denied housing based on arrests. We have somebody else again raising the issue of being able to take your voucher out of state and also the issue of splitting the lease to remove the abuser and allow the victim to stay in subsidized housing. So, so this is great. We actually have a ton of responses now. So it looks like a lot of you are seeing several of the issues that we've raised already, as well as some additional issues. So it's really interesting to see that although we're from all over the country, many of us are encountering the same obstacles to keeping our clients housed and getting our clients into housing. So with that, I now want to turn it over to Navneet. Now that we have a sense of what the issues are and a sense of the obstacles our clients are facing, I want to turn it over to Navneet now so that she can talk about the basic legal protections that our clients have. Then we'll come back to the case studies and talk about how they were resolved. And also, as I mentioned, Navneet is going to talk about the substantive law. And we sent out some supplemental materials this morning that contain more detail than what you're going to see on the slides. They contain things like the legal citations and some of the language from the statutes and regulations. So that information is going to be more detailed and give you a greater background than what you're going to see on the slides. So consult that and also contact us if you need more detailed information than what we're presenting today.
Thanks, Malia. So now we're going to go over what exactly are these housing protections that everyone keeps talking about. So as many of you probably already know, VAWA was initially passed in the mid-90s, but the housing provisions weren't passed and didn't become effective until about 5 years ago. And they address domestic violence, dating violence, as well as stalking in the following ways. There's protections against discrimination in admissions to subsidized housing. There's protections against evictions and subsidy terminations. And the subsidy terminations are relevant for the voucher holders. Safety moves. There are rules regarding how one might remove the perpetrator from the subsidized unit. And there are rules describing how you can provide the proof that domestic violence, dating violence, or stalking has occurred. And I just want to note that I think that this covers a lot of the types of situations people have seen. Where can you actually find these rules and regulations? The housing statutes are at 42 U.S.C. 1437D and at 42 U.S.C. 1437F. The way VAWA is written is somewhat confusing, so I'd like to, we do have a sort of statutory compendium on our website, which we'll show you at the end of the webinar, where you can find that sort of explains how VAWA's housing protections fit into the existing statutes. And then HUD issued final regulations implementing VAWA recently on October 27, 2010. And these regulations contain a lot of really helpful language, especially in its question and answer section before the final rules. And some of the major issues that it addressed that have been confusing for a number of years are, what does actual and imminent threat mean? We'll talk about that in a little bit. What do you do when there's a family breakup? And then also the issue of what documentation is sufficient. The regulations are a really great resource for finally addressing some of those questions that have been plaguing advocates for a few years. HUD has also issued notices to housing authorities as well as owners, and these are available on HUD's website. And they mostly just say what VAWA statutory protections are, but may be useful in advocacy just to reinforce to housing authorities or owners what their duties may be. Okay, so what does VAWA do in terms of providing protections and admissions? What the language says is that public housing authorities and owners of the subsidized housing shall not deny admission to their housing on the basis that an applicant has been a victim of domestic violence. What does this really mean? Does this prohibit public housing authorities and owners from denying admission based on poor credit or tenancy history that's directly related to domestic violence, dating violence, or stalking? For example, say that there's poor credit history because the abuser controlled the finances and used financial abuse as one aspect of the abuse. And so we're going to go ahead and take a poll right now to see what you all think.
Okay, everyone. So as Navneet said, VAWA prohibits housing authorities from denying housing to someone based on their status as a victim of domestic violence. But does that prohibit housing providers from denying housing to someone based on negative history, such as negative tenancy or credit history, that was related to the incidents of domestic violence committed against the client? So your choices are yes, no, and maybe. And I can see people voting, thinking about it. This is a close race, very exciting. So we've got over half voting now. And I'll wait until it gets about to 3/4, and then we'll close the poll. All right. So let's share the results. So 27% of you said that VAWA does prohibit housing providers from denying admission to a victim based on negative history related to domestic violence. 30% of you were more skeptical and said no, and some of you said maybe yes, maybe no. So Navneet, what do you say?
I'd say maybe. And have we closed the poll? Can people see my screen again now?
Here, let me close it.
I think I did.
Okay, great.
Okay. So I would say that the people who said maybe are probably the closest to the right answer. What you really need to do here is make sure that as advocates you can show a nexus between the negative credit or tenancy history and the domestic violence. A number of advocates have made these arguments, and several of them have prevailed with their local housing authorities or landlords, while some of them have not been able to prevail. And a lot of times it really depends on how closely you can tie the two, the effect of the domestic violence and the actual act of domestic violence together. Do you have anything you want to add, Malia?
I'll just provide one concrete example that was resolved favorably and for the client so that we can bring it to a more practical level. So we received a call about a case where a domestic violence survivor was denied housing because she had been previously evicted from public housing. And the reason why she was previously evicted from public housing was because she had fled her public housing unit to move into shelter for her safety. And of course, during that time while she fled, she was not paying rent and faced a non-payment eviction. And so the advocate was able to document the time and dates in which the client was living in shelter and show that it was impossible for her to be in contact with the housing authority at that time. And also, she in fact later on did try to get in touch with the housing authority to let them know why she hadn't been paying rent and why she hadn't been living in the public housing unit. And so as a result of that documentation, the housing authority did reconsider its decision to deny her her application for a Section 8 voucher.
All right, thank you. Okay, so there's similar protections in the evictions and terminations context. What VAWA says is that crimes against the survivor directly relating to domestic violence are not grounds for evicting the survivor or terminating her rental subsidy. So what are some of the types of things that come to mind in terms of evictions or terminations that are directly related to domestic violence? Some of you may be familiar with the fact that a number of housing authorities or landlords have zero tolerance for crime policies. So say that there's an incident of domestic violence where the police are called to the apartment. A number of housing authorities will automatically evict for this that situation. What VAWA does is say that if the police are called based on domestic violence, you cannot evict the victim because of that. Another example that someone brought up in the when we discussed some of your own situations was property damage. You know, say someone's being evicted for having a broken window or a broken door because their abuser had broken into the home or broken something. It's another situation where you can demonstrate that those crimes are directly related to domestic violence or stalking or dating violence. And then the survivor should assert the protections of VAWA. An incident of actual or threatened domestic violence does not constitute a serious repeated lease violation or good cause for evicting the survivor or terminating their rental subsidy. And those of you who work a lot with the subsidized housing programs will recognize that you can be in the lease and in the rules and regulations, it says that you can be evicted or your subsidy terminated for serious or repeated lease violations. And what those actually are is sometimes ambiguous, but what VAWA does make clear that TV-related violence or lease violations are not cause for evicting the survivor. And HUD has demonstrated, you know, sort of what it thinks of VAWA. Secretary Sean Donovan said that VAWA recognizes the need to protect victims of domestic abuse from being evicted just because they were victimized. And no one should be afraid of losing their home if they report abuse. So I just think this language is really helpful in sort of getting to the purpose and the essence of the statute, and when you're doing your advocacy of sort of reinforcing that to the housing providers. What are the limitations and exceptions here? You all may hear sometimes housing providers say, well, I don't want to be liable for keeping this person in this housing when it could be dangerous and I could be, subject to a lawsuit for not maintaining safe housing. Well, what VAWA does to sort of anticipate this is that PHAs and owners can still evict or terminate a subsidy if they can demonstrate an actual and imminent threat, and I really want to highlight and, to other tenants or employees at the property if the survivor is not evicted. And for a long time this was, debated what this actually meant. Many housing providers developed an actual or imminent threat standard. But fortunately, the HUD regulations that came out in October provide a little bit more guidance on this issue and have some discussion on it. First, they defined threat. What does a threat mean? What it consists of is a physical danger, not a verbal danger. It has to be physical, that is real, would occur within an immediate time frame, and could result in death or serious bodily harm. So one of the things I want to really emphasize here that this is an objective standard, and it's not just something that makes other people uncomfortable, but that's a real threat to others. The factors that are to be considered include the duration of the risk. Is this something that's been going on for a long time? Is it something that just recently started happening? The nature and severity of the potential harm, as it's noted up here, is it death or serious bodily harm? The likelihood that the harm will occur, and the length of time before the harm would occur. Is there time to set up safety precautions and whatnot? And a lot of this is borrowed from the, if some of you are more familiar with the disability context and direct threat, some of these factors are borrowed from that analysis. And you can find those regulations defining this at 24 CFR 5.2005. Okay. Now that we've talked a little bit about what the statute says and what the exceptions are to asserting these protections, talk about some more of the details. So frequently what a person's going to want to do is to remove the abuser from the household, or to remove them from the subsidy. So a housing authority or a Section 8 landlord may bifurcate a lease to evict a tenant who commits to domestic violence, while at the same time preserving the survivor's tenancy right. So that means for the housing provider who's providing a direct subsidy, they can evict only one household member. And for the voucher, it may be that you actually, depending on your housing authority, you can actually split the voucher into two, or that you can remove the abuser from the voucher and solely give it to the survivor. It's important to note that while VAWA provides protections, you still have to maintain the tenant's rights protections for all parties involved. So the PHA or the landlord must follow federal, state, and local law in evicting the perpetrator. You can't simply kick someone out. You have to go through the eviction process. Safety planning is really essential in these cases. So, attorneys should really work with advocates in these situations, people who are really experts in ensuring that the survivor will be protected. For example, if maybe the housing authority is going to evict the abuser from a public housing unit, you would want to work to make sure that maybe the survivor has another place to go during the eviction process, that any information they provided is confidential, and all of those sorts of things that there are people with the expertise. So it's really important to consider that. And as I noted, the PHA may terminate Section 8 assistance to the abuser while preserving the assistance to the survivor. Again, there is a process for terminating assistance that the housing authority has to follow. The abuser has the opportunity to have a hearing. If the family splits up, the PHA must actually ensure that the victim is the one who retains the assistance. And this can be found in those new regulations and the final rules. Let's get rid of that. Okay. So moving on to portability. So we've mentioned a few times that one key characteristic of a Section 8 voucher is that you can move it anywhere. You can move it within the city that you're already in. You can move it out of state, anywhere where there is a public housing authority that can receive and administer the voucher. But there are a number of issues that arise. Sorry, it's frozen. There we go. All right. So one of the issues that's come up is that a survivor will want to move. She's in the middle of a lease term. In a number of occasions, the housing authority has said, well, we'll let you move, but you have to get permission from your landlord first. That is inappropriate under VAWA. The family, if they've moved out in violation of the lease, while usually the housing authority could terminate their subsidy because of this, they cannot if it's because of domestic violence. If someone is moving in violation of their lease in order to escape from a DV situation, then you cannot terminate the subsidy. And in a related issue, a number of housing authorities have policies, and you'll see them in the administrative plans that we mentioned. It's in most administrative plans that a Section 8 tenant can't move during their first year of the lease. You get the voucher, you have a one-year lease term, and you can't move your voucher. This policy does not apply when the move is needed for safety. And again, you can find this in the regulations. And I think this is an area that you particularly sometimes will see the housing authority not sure what to do because they're not sure how to maintain relationships with landlords and allow this. But the new regulations are really clear on this issue. And then what happens if you don't have a Section 8 voucher, but your subsidy is a hard unit? You're in public housing, you're in elderly housing. What do you do? Can you transfer a unit? Unfortunately, this is one of the areas where VAWA has been largely silent, and so a lot of the policies here really are related to advocates, what advocates have pushed for and been able to get. So say you're in a public housing unit and you need to move to another unit to protect your safety. It's both important to raise the issue that with the housing authority, let them know immediately that there's the transfer is needed because of safety related to DV. And Malia, I think, will talk a little bit more about what kind of advocacy you can do. But there may be, policies in the Public Housing Authority's plans, the ACOP, which we mentioned before, that will have a process for emergency transfers. And again, Malia will get into a little bit more detail about that. Okay, so another big issue is proving a domestic violence. What documentation is needed? So assume that the PHA or landlord seeks to evict because of a lease violation. They said that, we saw police show up to your place 2 times last week. And the tenant says, well, the violation is related to an incident of domestic violence, so you can't, don't evict me. I'm protected under VAWA. The housing authority or the landlord can take the tenant at her word. For example, if they've sort of recognized that there's been some incidents of domestic violence, they accept it. They don't need to ask for any documentation. They can just leave it at that. But they also have the right to ask the tenant to prove domestic violence. Any request must be in writing, and the tenant has 14 business days from the date of that written request to provide the proof. It may be difficult sometimes to get that information in 2 weeks. So the PHA or landlord is free to grant an extension, again in writing, if the tenant needs more time. And what documentation is sufficient? The tenant can provide any one of these 3. There's often been confusion about whether or not you have to have more than one of these, but any one should suffice on its own. HUD has a self-certification form, which I will show you on our next slide what that looks like. And that's a self-certification.
And it was also included in the materials that was sent out to the registrants today.
A police report or a court record, including a restraining order and whatnot, a protective order. Or a statement signed under penalty of perjury by the survivor and a DV service provider, medical professional, or an attorney to certify that there has been, that the person is in fact a survivor. Generally, the documentation must be kept confidential by the landlord or the housing authority. That means that only people who need to see the information can see it. You can't keep it in a database. The one big exception is that if the housing authority or the landlord needs the documentation to evict the abuser, then they can use that information. So that is a big exception, and if that's necessary, the housing provider should, you should make sure the housing provider knows that they should inform the tenant so that they can come up with a safety plan. So here is just what the certification form looks like. One of the things that HUD did do to sort of balance the need to make sure that people don't falsely assert is say that you can be, your subsidy can be terminated or you can be evicted if the information here is false. But otherwise, just a self-certification. So one of the other big issues with documentation is whether or not a housing provider can require a tenant to provide third-party proof of domestic violence, dating violence, or stalking. So in their recent final rule, HUD stated that an individual requesting protection cannot be required to provide third-party documentation. The only exception to this is where both household members, or two of the household members, both claim to be the victim and name the other household member as a perpetrator. And in this case, HUD urges that the housing provider really look to people who have more expertise on figuring this out, such as domestic violence advocates, police, and social workers who are more familiar with the signs of domestic violence and who the survivor is and who the abuser is. Other requirement is that PHAs must provide notice of VAWA's protections to public housing tenants, Section 8 tenants, and landlords so that everyone knows that they can assert this. And we've just included in here a sample of what one actual housing authority sent out. It's pretty basic and simple. Additionally, in their annual plans that we talked about, housing authorities must state how they are helping survivors of domestic violence access housing. So both in the PHA plan, which is called the annual plan, and the attachments, which are the administrative plan for vouchers and the ACOP for public housing. So that is basically the main range of what VAWA and the regulations specifically address. There's a lot of issues that this doesn't address, but the Housing Authority has a lot of discretion, and the advocacy may really have a huge impact on an outcome. So Malia is going to discuss now what happened in those case studies that we talked about and some of the strategies that people can use.
Thanks, Navneet. So let me get the slideshow rolling again. And so as Navneet mentioned, we're going to go back to the case studies that we talked about at the very, I guess, towards the middle of our presentation and talk about what the outcomes were and what some of the actions were that the advocates took in those cases. So first I'll start with Eva, and if you'll remember, Eva was our client who applied for public housing and was denied public housing because she had been arrested for assault. And in fact, the charges were dropped against Eva. She was the victim rather than the perpetrator of that assault and had been arrested because of her inability to adequately communicate with the police. And so in that case, Eva's attorney contacted the Housing Authority and noted that, as Navneet mentioned, VAWA prohibits housing authorities from denying housing to a victim because of the domestic violence committed against her. And the advocate pointed out to the Housing Authority that Eva's arrests were directly related to domestic violence. And this illustrates an issue that you'll see again and again in working on VAWA cases, is the need to establish the link between the negative event and incidents of domestic violence committed against your client. In Eva's case, her advocate put together some documents showing, again, that the charges against her had been dropped, also showing that she had sought services for help with the domestic violence that had been committed against her. Again, establishing the link between the arrest record and the fact that she was a victim of domestic violence. And also, the attorney explained the issues of limited English proficiency and also explained to the Housing Authority that, sadly, it's not uncommon for an immigrant survivor to be wrongly arrested. Another important thing that could be brought up in Eva's case is that HUD had some really great language in the VAWA regulations that it recently promulgated. And HUD stated in commentary before the regulations that victims of domestic violence, dating violence, or stalking must not be denied assistance based solely on a criminal history related to domestic violence, dating violence, or stalking, which is a really great statement for those of you who are trying to assist survivors of domestic violence who have criminal records and who want to apply for housing but are worried that they're going to be denied because of a criminal record related to the DV. Another thing that Eva's attorney pointed out is that past arrests really are not good evidence of what type of tenant a person will be because, again, it was just an arrest and it wasn't a conviction. Another thing her attorney pointed out was that denying someone housing on the basis of an arrest is very arbitrary and discriminatory, especially because, you know, people of color, arrests have a disparate impact upon them. They are, unfortunately, greater in numbers among the people who are arrested than the general population. And so denying someone housing based on their arrest record could certainly have a disparate impact based on their race. So ultimately what happened was that the Housing Authority later offered a unit to Eva and disregarded the criminal, the assault arrests. I now want to turn back to Sonya and talk about what happened in her case. If you recall, Sonya was the survivor whose abuser had broken into her Section 8 voucher assisted unit. He had caused some damage and cut himself, and he told a security guard at the property that he had been stabbed. And the housing provider then decided to evict Sonya based on nuisance because of this alleged stabbing. In that case, Sonya's attorney raised VAWA and the Fair Housing Act as a defense to the eviction. They raised it as part of the answer in responding to the eviction complaint. They also filed a motion for summary judgment to get the judge to see that this was a legal issue, that Sonya was protected by VAWA, that this case should not even go to trial. As part of the pleadings in that case, Sonya provided police reports, her restraining order, and also evidence that the city declined to prosecute her for this alleged stabbing. And in fact, the court found that VAWA prohibited Sonya's eviction. And this is actually a great published case on VAWA, one of, I think, maybe perhaps the only published case we have where a survivor raised VAWA as a defense to eviction. And you'll see the citation there. The case is also included in the materials that we emailed out earlier this morning. So on this slide, we have an excerpt from the answer that Sonya's attorney actually filed to the eviction complaint, and I wanted to highlight just a piece of it. One thing that the attorney did was just to go through the history of the domestic violence that had occurred against Sonya by the perpetrator. And she had provided, for example, she had done basically everything she could do to prevent this person from coming into the property and harming her. She'd given copies of the order of protection to building management and security, along with a picture of the perpetrator. And what her attorney said in the answer to the eviction complaint was that under VAWA, it's unlawful for a landlord to terminate the tenancy of a Section 8 tenant solely on incidents of domestic violence. And the attorney said the proceeding was based solely on incidents of domestic violence and had to be dismissed because the only grounds cited for evicting Sonya was this alleged, again, these alleged incidents of domestic violence and the alleged stabbing that, as we know, she did not commit. And the court agreed and issued a really great opinion. And one thing that I wanted to note about the opinion is that it really talks about the dynamics of domestic violence and how they sort of presented themselves in this case. One of the things that the landlord said was, you know, we've heard that she's allowed him back in the unit. And I'm sure several of you have often heard that argument with a housing provider saying, what are we supposed to do? We think your client is allowing this person on the premises. And the court said, you know, Sonya might have changed her mind after she got her restraining order and allowed the perpetrator to access the unit. But that type of behavior toward a perpetrator really fits into the cycle of violence. The court notes that domestic violence is cyclical in nature. Victims really anticipate oncoming violence, and you know, this entices, and the batterer's behavior can entice her to remain with the abuser even after the violence ends. And as a result of examining the dynamics of domestic violence as well as the evidence of domestic violence that was presented in this case, the court found that Sonya was in fact a victim of domestic violence and that VAWA prohibited the housing provider from terminating her tenancy or evicting her. And so again, we really like the word here. The landlord was forbidden from evicting the client based on this alleged incident of domestic violence that occurred in the unit. And so this case is a great example of how VAWA has been used defensively to prevent the eviction of a Section 8 voucher tenant. So I now want to go back to Maya. And Maya was the individual who had missed a couple of meetings with the housing authority because she was afraid to leave the unit because of stalking. And she gave the housing authority that HUD certification form that Navneet showed you earlier in order to document the stalking against her. And the housing authority turned to her and said, we need something more. We need something from a third party showing that you are a victim of stalking. And so Maya's attorney got in touch with the housing authority and wrote a letter explaining, as we've already discussed, VAWA does not require third-party documentation. And HUD has now made very clear that tenants cannot be required by a housing provider to provide third-party documentation of domestic violence, stalking, or dating violence. The attorney also explained why the nature of stalking made it impossible for Maya to leave her home. Again, this is this issue of being able to establish a link between the program violation or the lease violation and the violence committed against your client. Here, the attorney really went into the details of the stalking committed against Maya, explained that she was under constant surveillance, that this person followed her everywhere, that he had threatened to make her life a living hell. He engaged in all kinds of threats against her, and explained how this all combined together made it virtually impossible for her to leave her home in order to protect her safety. And the attorney argued that to terminate Maya for missing those meetings would be the same as terminating her for being a victim of stalking in violation of VAWA. And ultimately, the housing authority accepted Maya's certification form, and it ceased its efforts to terminate her from the program. So now let's turn back to Jen's case. And Jen was our client who has Section 8 voucher with her husband and kids. And the housing authority, after she got a restraining order against the husband, ended up assigning the voucher to the husband because he was the head of household. So Jen's attorney wrote a letter to the housing authority arguing that the termination of Jen's assistance when the family broke up violated VAWA. And the attorney noted that, first of all, housing authority failed to follow the HUD regulations that recently came out. As Navneet stated, the new regulations make very clear that if a family breaks up due to domestic violence, the housing authority must ensure that the victim retains assistance. And that is not what happened in this case. And as it turned out, the housing authority was actually in violation of its own policy, its own Section 8 administrative plan. Its own plan stated that when a family broke up, they would consider the interests of minor children, and they would also consider the role that domestic violence played in the breakup. And the housing authority completely failed to look at that plan when it assigned the voucher to AJ, the husband. So Jen's attorney requested an administrative hearing. He wanted to challenge the fact that the housing authority had assigned the voucher to the husband. And he also wanted some homeless prevention funds to cover Jen's back rent. She hadn't been able to pay the rent without the voucher assistance. And ultimately, the housing authority agreed to issue Jen a voucher of her own, as well as homeless assistance. So now I want to turn to Isabel. Isabel was our client who had moved out of the unit she was renting with the assistance of a Section 8 voucher. And she had moved out even though it was the first year of the lease and had moved without notifying the housing authority first. And the housing authority had not the Housing Authority stated that it would terminate her voucher for failing to notify them of that move. Isabel's attorney got in touch with the Housing Authority and notified the Housing Authority that restrictions on moving during the first year of a Section 8 lease do not apply to moves for safety. In other words, you cannot be denied the right to port just because you are moving due to domestic violence during the first year of your Section 8 lease. And this is, again, something that HUD clarified recently in October, and we're still seeing that many housing authorities are unaware of this. And so it may be something that you see in your practice where you have to inform the housing authorities of the new regulations, making very clear that domestic violence victims can move during the first year of the lease. The other thing that the attorney pointed out was that even if Isabel had moved out of the unit without notifying the housing authority, it still could not terminate her voucher, again, because she had moved for her safety, and VAWA provides an exception of the requirement that you notify the housing authority before moving. Unfortunately, the housing authority still refused to allow Isabel to use her voucher at her new home. And what she was forced to do was to file a fair housing complaint with the Department of Housing and Urban Development. And this mechanism or this tool is something we'll get into more in the March 23rd training on fair housing. But I want to point it out as another tool that you can use in your advocacy, another way to get a housing authority to do the right thing. So in Isabel's case, her attorney assisted her in filing a complaint with HUD against the housing authority. And ultimately, HUD conciliated that agreement between the parties, and the housing authority allowed Isabel to move with her voucher out of state and continue to receive voucher assistance at that new unit. So that wraps up our client stories. This is a great time to submit questions if you have any questions about what we've discussed today. And if we have time, we'll also discuss some of the questions that were submitted during registration for those of you who did that. And also, we know that several of you are experienced in VAWA advocacy. If at this time you want to share some successes or strategies you've used using the question box, that's also appreciated. So I just wanted to do some takeaway points before we get to the questions. So first I want to talk about assisting survivors in applying for subsidized housing. During intake, advocates may need to ask questions to determine whether a denial of housing was related to domestic violence. We talked about survivors are denied housing based on arrest records. So it may be necessary to ask the survivor, well, why were you arrested? Did it have anything to do with violence that has been committed against you? Or why do you have negative tenancy history? Was it because of something the abuser did at the prior apartment? If a client was denied housing based on her status as a domestic violence survivor, raise VAWA to try to get her into that subsidized housing. Unfortunately, housing providers often fail to see the link between domestic violence and negative history, so it's often up to us as advocates to show them why a survivor might have an arrest record, or why she might have a negative tenancy report from a prior landlord, or why she might have previously been evicted from subsidized housing. If you have a client who's been denied housing for reasons related to violence committed against her, she has a right to an informal review to challenge that denial, and she can present factors showing that the denial of housing was related to violence committed against her. Another strategy is to take a more, proactive approach in working with housing authorities to develop policies that consider domestic violence as a mitigating factor when housing authorities are thinking about who they're going to admit into the program. And we have sample policy language that you can use that directs housing authorities to consider whether someone's negative tenancy or credit or criminal history was related to acts of violence against them. So I now want to talk about issues that your clients may have while they're in subsidized housing and some of the takeaway points there. As we discussed several times today, domestic violence survivors can move with Section 8 vouchers, and several of the usual restrictions do not apply. Again, the usual restriction that you can't move during the first year of your lease, or you can't move more than once during a 12-month period. Those restrictions should not apply to people who are moving because of domestic violence. As we discussed, under VAWA, a public housing lease, a Section 8 lease, or a Section 8 voucher can be split to remove the abuser. And I can't emphasize enough that head of household status is not controlling. A lot of housing authorities seem to still think that whoever is head of household automatically gets the public housing unit or automatically gets the voucher. And HUD has made clear in its new regulations that when a family breaks up due to domestic violence, the survivor needs to retain assistance. Another issue that we discussed is housing providers cannot require third-party documentation of domestic violence in order for a survivor to be able to assert her VAWA rights. There is an exception, though, if two members of a household both claim that the other is the perpetrator. So I just want to do a couple closing points on domestic violence-related evictions and subsidy terminations. So as we saw earlier with Sonia's case, VAWA can provide a defense to an eviction or subsidy termination if the lease or program violation is related to domestic violence. It can be raised as an affirmative defense in the unlawful detainer or eviction answer, and it could be raised at the informal hearing regarding termination of a survivor's voucher assistance. And just that segues into the next point, that a client should exercise her right to a hearing to challenge a termination or eviction and use that venue to raise VAWA. It's really critical to urge housing authorities, of course, to take steps short of termination and eviction, such as helping the client relocate to a confidential location. Finally, it's important to train housing authority staff on VAWA provisions and the dynamics of domestic violence, dating violence, and stalking. And we have some sample training materials if you're interested in doing that with your local housing provider. So with that, we're going to take some questions from our registrants. And also, again, if you want to submit tips or tricks that you've used in VAWA cases or share a success story, that's appreciated as well. So as we mentioned at the beginning of this presentation, we're all here to support you in your work that you're doing with survivors of domestic and sexual violence. And you'll see our contact information on the final slide. And we're happy to take questions via email or by phone. You also see here our website. And I'll show you the website here in a minute. Okay, so let me back up here a minute.
Sonya, while you're pulling that up,
yeah,
I just wanted to note that a number of people have asked. Some people didn't receive the materials, and some people didn't needed some of the sites. And the materials will all be posted here where Malia is about to show you where on our website it is, and it should also have the citations for the cases that we mentioned, as well as some sample form letters and whatnot.
Yep. Thanks, Namni. And I also want to do a reminder here as well. We'll be sending out an evaluation. It'll be an online evaluation form, and if you could complete those, that would be great, because we do really seriously consider your feedback. So I'll just quickly show you the website. We set up a website specifically for legal assistance for victim grantees. Of course, it's accessible to the general public as well. We also have a general domestic violence and housing website. You'll see on the website we have a link, a registration link for the next webinar. Probably one of the things that is most relevant to those of you who want to learn more about VAWA's housing protections is our VAWA Housing Toolkit. And this contains a document that lays out where you can find all the statutory protections that we've talked about today. It has sample advocacy documents such as pleadings and demand letters. And it talks about some of the administrative guidance that's been issued. So please do check out our webinar and if our website. And if there's a resource that you need but you can't find, just let us know because we likely have it somewhere. So with that, I think we'll turn to questions.
Okay, so there's a number of questions, and what we'll do is if we don't get to all of them, we may follow up by email.
Yeah.
Okay, so the first question is, well, first I'm going to start with the question of what's the difference between portability and transfers?
Oh, sure. And that's a great question, and I think we probably could have done a better job of clarifying that. Portability applies to the Section 8 voucher program, and it refers to the process of taking your Section 8 voucher and using it in another jurisdiction with the help of another housing authority. Transfers apply to the public housing program and the project-based Section 8 program, and a transfer means that you're being transferred from one public housing unit to another that's being operated by the same housing authority. So again, transfer, we use the terminology transfer when we're talking about public housing, and we use the terminology portability when we're talking about a Section 8 voucher.
So that said, if you are in a hard unit and transfer is a reasonable, it's a feasible alternative to an actual and imminent threat, is the landlord or PHA required to make the transfer?
So that is a wonderful question because it was recently addressed in the HUD regulations that will be a part of the materials that will circulate again after this webinar. In the regulations, HUD makes clear that you cannot evict someone, you cannot evict a victim who you argue is an actual and imminent threat to others if there are alternatives to eviction, such as transferring that victim to a safe, confidential location. So, and I saw that somebody posted the question, well, why would a housing authority evict rather than allow a transfer for the tenant's safety? And really, they should be transferring the tenant instead of evicting, and they're obligated to do that under the new HUD regulations.
Great. So the next question is that if a survivor is evicted from non-subsidized housing, so they have that on their tenancy report, can the PHA deny? So the question is, does the protections and admission apply when the tenancy history is based on private housing?
I would argue that if that eviction from private housing was related to an act of domestic violence committed against your client, an act of domestic violence, stalking, or dating violence, I would argue that it doesn't matter whether she was evicted from subsidized housing or unsubsidized housing. It still bears on her status as a victim of domestic violence, and she should not be denied access to housing because of that. The
next question is, does VAWA apply to male tenants?
So the definitions of domestic violence, dating violence, and stalking found in VAWA are gender neutral. So even though the statute's called the Violence Against Women Act, male survivors of domestic violence are still entitled to VAWA's protections. And also along the same lines, same-sex couples can also assert, someone who's in a same-sex relationship could also assert VAWA's protections.
Okay. Do we have form letters to public housing authorities and landlords available in the materials or our website?
So we do have some. I'm trying to think of the best way to access that. So you'll see on this slide, we have the link to our resource center, and this one has some of those sample documents. You'll also see on our website in that left-hand column that I showed you earlier that we have a general domestic violence and housing website. And on that website, there's a domestic violence and housing manual that has a number of sample letters and documents. That manual is specific to California, but the sample documents would apply regardless of what jurisdiction you're in. And we're also planning to produce a national manual within the next couple of months that will have a lot of sample documents in it.
And then this is a related question, is what happens if the housing authority doesn't respond to repeated letters? You talked a little bit about enforcement, but what are some options?
Right. So for one thing, HUD has become very interested in this issue. So you may want to consider contacting your HUD regional office if you want help with that. Feel free to contact us and ask them to intervene. Another thing we touched on is that you can also file a fair housing complaint with HUD. If you're doing that, we'll talk about that more in the March 23rd webinar. But if you're doing that, you'll both want to raise the VAWA violations, but you also want to argue that it's a violation of the Fair Housing Act. HUD is going to be more likely to look at those types of complaints if you raise some sort of sex discrimination argument. And again, that's something we'll talk about more on March 23rd. Other things, housing authorities are governed by boards, and if there's repeated noncompliance, this is something you might want to bring up with the board.
Thanks.
And then I guess other things are to think about is do you have some sort of administrative procedure under state law that you could use to challenge the housing authority's decisions?
Okay, so speaking of state law, what is the liability, if any, if someone, a survivor, terminates their lease early?
So I'm guessing, I'm just going to guess that the questioner is asking what happens if you're a Section 8 voucher tenant, you break the lease to move with your voucher, and you broke that lease with a private landlord. What's your liability as a tenant? So that's unfortunately not addressed in VAWA, and I believe that it varies depending on state law. We know that there are about 20 states that have laws allowing domestic violence victims to break their leases early without financial penalty. And the rest of the states, there are other arguments that can be made. You can make contract arguments stating that it was impossible for the client to continue living there because of her safety. We also have an article that was written about this topic. So if the person wants to contact us offline, we can tell you more about breaking the lease and potential advocacy that can be done in that area. But again, I think it boils down to looking at whether you have any state law protections and also whether there's any state case law, perhaps in the contract context, that could protect your clients.
We have a lot of questions, so sorry, I'm going through these quickly. The next question is sexual, non-intimate partner sexual assault covered by VAWA?
So unfortunately, NAVNEET put up the categories of people who are protected under VAWA, and it says domestic violence, dating violence, and stalking. And sexual assault is not explicitly listed among the categories of protected victims. So we encourage people to look closely at the definition of stalking to see, because in VAWA, stalking as defined in VAWA is not defined in terms of an intimate partner relationship. So it might cover some instances involving sexual assault. But really what's needed is probably a change to the statutory language so that sexual assault victims are explicitly covered under VAWA. And I believe that's something that advocates are looking at as part of the next reauthorization of VAWA.
How often do PHAs have to notice tenants and landlords of VAWA's protections?
So this question about how often do PHAs have to tell landlords and tenants about VAWA, it's not addressed in the statute, and it hasn't been addressed in any guidance put forth by HUD. I think as a result of that, since there's no great national guidance on this topic, it's something you have to work on locally with your housing authority. Arguably, they should be giving notice to every tenant who applies, and they should be giving notice to tenants at their annual recertification appointments where they meet with the housing authority to discuss their income and any changes to the household. You could also talk about the housing authority perhaps doing an annual mailing, but we've heard from some advocates that that approach is not as successful because often the abuser is the one who is getting the mailing. Another place to ask housing authorities to notice people about VAWA is in any denial of assistance letter or in any letter terminating assistance or proposing to terminate a public housing tenancy. So again, this is an area where some local advocacy is needed.
The next question is a little bit complicated.
Okay.
It's a standard of proof question, and is the standard of proof the same to evict the defendant as it would be to not evict the victim? So what are I guess it's two separate questions really. What's the standard of proof for not evicting the victim, and the standard of proof for evicting the defendant?
Wow, I really don't think I know the answer to that question, and if anyone does know, feel free to enter your answer in the chat box. I think the eviction standard is going to depend, frankly, on what the practice is of your courts, but the not evict standard put on victims, I haven't really seen that addressed anywhere. It certainly hasn't been addressed in the case law. So it's hard to know how much evidence you would actually have to set forth as a victim to prove that you cannot be evicted. Unfortunately, the best we can tell you is just to come up with all of the evidence and documentation that you can. I know that answer is completely unsatisfactory, but without seeing, without having more cases actually litigated or actually brought forth in the eviction courts, it's hard to know what courts are going to require a victim to show.
Yeah. And one thing I would add for evicting the abuser is just that there are due process. You are required to have basic due process, and some circuits have interpreted it differently. But I would imagine that because you are losing a government benefit as opposed to maintaining one, it is a fairly high standard.
Yeah, that would be my best guess as well.
Yeah. And then, so what about, okay, so this is sort of a question related to, PHAs often have the restrictions on moving in 1 year. What happens in subsequent years after that first year with regards to portability?
Right, so that usually depends on local housing authority policy. I don't think that that's an issue that's addressed in the regulations. The one place that we do see it come up is many housing authorities have a rule stating that you cannot move more than once during any 12-month period. But HUD has made clear that when you need to move for domestic violence, that rule does not apply to you. So even if you're in subsequent years after the first year of your Section 8 lease, you need to move more than once during a 12-month period, and it's due to domestic violence, you can't be restricted from taking your voucher and going someplace else.
Okay, so there's just two more questions since we're about to, it's about time to wrap up. What can a tenant be evicted if they've been arrested because of an incident of domestic violence? And I know you talked about this in some of your examples, but if you just want to reiterate that.
All right. So again, it's important in these cases to look closely at the statutes and regulations. I think, frankly, it's going to depend on the facts of the case. So if you do have a case like this, please contact us, and we'll go over the specific facts. If the arrest is related to domestic violence, and again, you can establish that nexus between the arrest and acts of violence committed against your client, certainly you can raise VAWA as a defense in the eviction proceeding. And if you have the evidence, hopefully you'll be able to prevail. It's sort of similar to the Sonya Thorpe case that we talked about earlier. Although she wasn't arrested, she very easily could have been because of the abuser's allegation that he had been stabbed by her. But her attorney was able to present evidence showing that she was in fact the victim and that the charges weren't actually brought. And so she was still able to assert her VAWA protections. So again, it's going to be probably a fact-specific type of analysis. It might depend on the individual circumstances of the case. But in general, there's no reason why VAWA shouldn't apply just because you've been arrested.
Okay, and so the final question is that somebody has a case where their client is in shelter plus care and they say they cannot port this. Do you have advice on where you can get information on protections for shelter plus care?
Oh boy. The reason why I say oh boy is that Shelter Plus Care is not one of the programs that is covered by VAWA. Again, that's something that probably needs to be addressed in the reauthorization. But in any event, you can still raise fair housing arguments on behalf of that client. As we'll talk about next month, courts have found that discrimination against domestic violence survivors can constitute sex discrimination, and that violates the Fair Housing Act. So, it's hard to say without knowing more about the case, but I would recommend looking at some of the fair housing domestic violence discrimination cases and look at the arguments that have been raised in those and try to think about how that might apply to your clients. And we're also happy to talk offline to get more facts about that case.
All right. So it is 12:32.
All right, so that means we have to wrap up, and I know that several of you submitted questions online as part of the registration process, and we didn't get to those. So we're happy to answer those offline for those of you since we weren't able to get to all of your questions. But again, I wanted to thank you all for being a really engaged and exciting audience. I know it's hard to be engaged in these webinars sometimes, but we really appreciate all of the questions and comments that you submitted as part of today's presentation. Again, our contact information is on this last slide. Please get in touch with us if you need any assistance. And we'll circulate a link to the recording of this webinar and the materials once again, probably by the end of next week. So thanks, everyone.